Thank you, Ciara. I too would like to welcome Minister Quinn to the House today, and I also welcome the opportunity to speak on this Residential Institution Redress Amendment Bill, which facilitates the winding up of residential institutions of the Institution Redress Board. The opportunity for claims under the residential redress has been available since 2002. The closing date for applications was originally 2005. However, it made provision for late applications in exceptional circumstances. Minister Quinn announced earlier this month that no further applications could be received after the 16th of September 2011, and I must say that I agree with this deadline put forward by the Minister, that this deadline of 16th of September must be upheld in order to facilitate the winding up of the Redress Board in a fair and timely fashion. I would also like to commend at this stage the Redress Board on the exclusive advertising campaign that they have carried out in the past, and the notice that will be given in the daily newspapers 6 weeks before that closing date. At the end of June 2011, the Board had received 15,170 applications, of which 14,645 had been finalised, leading to 13,720 awards. This, of course, was a far greater number of claims than was originally anticipated by the previous government. By the end of 2010, the overall expenditure on the redress scheme and associated litigation was £1.05 billion, including £836 million in awards made by the Board and £158 million in associated medical legal costs. I would like to express my disappointment at this stage at the level of contributions offered by the religious congregations to meet the cost of residential institutional child abuse. Only 12 of the properties offered by the religious congregations have been identified as of potential benefit to the state, and only 2 of the 18 congregations have agreed to positively make up the shortfall of £200 million. I would also like to say at this stage that while I understand the concerns of the proposers of this amendment, that it's now impossible to include Bethany Homes' claims in this redress bill, and I appreciate the fact that they have raised the issue. But I now hope and anticipate that the government will take positive alternative steps to ensure a mechanism is put in place to acknowledge the suffering of the Bethany Home residents. I would like to add that I personally, and indeed all of the Labour senators, are very hopeful that an alternative mechanism for recognition of the Bethany residents will be found. I would like to pay a personal tribute to Derek Leinster, who has worked tirelessly on behalf of all Bethany Home survivors and to bring their plight to public attention. I would also at this stage like to pay tribute to Minister Kathleen Lynch and Deputy Joe Costello, who have campaigned endlessly on behalf of the Bethany residents since 2002. I welcome the establishment of the Review Committee of the Magdalen Laundry survivors, chaired by Senator Martin McAleese, to examine the role of the state in these laundries and to bring the religious orders and the state together to provide a clear picture on their involvement in the Magdalen laundries. I would ask the Minister to reconsider and to consider the cases of the Bethany Home survivors in the review with the Magdalen survivors, so that the terrible scandals and the dreadful legacy of abuse victims in our institutions may finally be resolved once and for all. Thank you.